For months, Donald Trump's legal operation has relied on a single assumption: that time was on their side. Delay long enough, complicate the process enough, and eventually the system would slow to a crawl. Investigations would blur together. Public attention would drift. Judges would move on. Elections would intervene. That assumption just collapsed. In a sharply worded order that landed like a thunderclap inside Trump's legal team, a federal judge has now forced a reckoning that Trump's advisors spent nearly a year trying to avoid. This was not a procedural tweak. It was not a scheduling adjustment. It was a direct challenge to the core defensive strategy Trump has used across virtually every legal battle he's faced. The court has demanded transparency, not eventually, not selectively, but immediately. At issue is a vast collection of documents Trump's team has refused to hand over to prosecutors: emails, memos, internal communications, strategic discussions, materials tied to the events surrounding January 6th and the broader effort to challenge the 2020 election results. Until now, Trump's lawyers have shielded these materials behind sweeping claims of legal privilege, attorney-client privilege, executive privilege, confidential advisory communications, national security sensitivity. In many cases, these claims were asserted broadly, without detail, and without the supporting explanations courts typically require. That approach worked for a while. But courts are not obligated to accept privilege claims at face value. And when a judge begins to suspect that privilege is being used not as a shield for legitimate legal advice, but as a weapon to obstruct discovery, everything changes. That is precisely what happened here. The judge overseeing Trump's federal case issued an order requiring Trump's legal team to produce a detailed privilege log, a document that itemizes every withheld record and explains, line by line, why it should remain secret. Not general categories, not vague references, specific descriptions tied to specific legal justifications. Who wrote the document, who received it, when it was created, what it discussed, and exactly which privilege is being claimed, and why. This is the moment Trump's advisors feared, because a privilege log doesn't just protect documents, it exposes them. Once prosecutors see what exists, even without the full contents, they can challenge each claim individually. They can argue that certain communications were political, not legal, that others were shared too widely to be privileged, that some may fall under well-established exceptions where privilege simply does not apply. And perhaps most dangerously of all, a privilege log can reveal patterns that point investigators toward areas of deeper concern. That's why this order sent Trump's inner circle into immediate damage control mode. Behind the scenes, lawyers scrambled. Advisors demanded briefings. Some reportedly expressed shock at how quickly the court moved from patience to enforcement. Others quietly began asking a more troubling question: which documents are most dangerous if they're scrutinized? To understand why this moment matters so much, you have to understand how Trump's legal defense has operated up until now. Trump does not fight cases the way most defendants do. He does not rush to trial. He does not seek resolution. His strategy has always been attrition. Overwhelm the system with motions. Challenge every subpoena. Appeal every ruling. Create procedural chaos so dense that accountability becomes practically impossible. This isn't speculation. It's a pattern that stretches back decades, from business litigation in New York to tax disputes to congressional investigations to criminal probes. The underlying logic is simple. Courts move slowly, and delay favors the defendant who can afford to wait. But federal criminal cases, especially those tied to national democratic processes, operate under a different gravity. Judges in these cases are acutely aware of the stakes. They understand delay tactics, and once they conclude those tactics are being abused, their tolerance evaporates quickly. That's what makes this order so significant. The judge did not merely request clarification, she imposed a short, non-negotiable deadline. 5 days. No open-ended extensions. No broad excuses. The message was unmistakable. Either justify the secrecy properly or surrender the documents. For Trump's advisors, this isn't just a legal headache, it's a strategic nightmare. Many of the individuals whose communications may now be logged were not acting as traditional legal clients. Some were political operatives, some were informal advisors, Some were involved in messaging, strategy, or coordination efforts that blur the line between legal counsel and political action. Those distinctions matter enormously. Attorney-client privilege is narrow by design. It protects confidential communications made for the purpose of obtaining legal advice. It does not protect political planning. It does not protect public relations strategy. And it certainly does not protect communications shared widely among non-lawyers. If documents once labeled privileged are shown to involve non-legal actors or political objectives, the privilege claim collapses. And that's before considering an even more dangerous possibility, the crime-fraud exception. Under U.S. law, attorney-client privilege does not apply if legal advice is used to further or conceal criminal conduct. Prosecutors have already signaled their belief that some communications surrounding the post-election effort may fall into this category. The judge's order opens the door to that argument. This is why Trump's advisors are alarmed. The issue is no longer whether documents can be hidden indefinitely. It's whether the very act of explaining why they were hidden will expose vulnerabilities that prosecutors can exploit. Every entry in the privilege log becomes a potential pressure point, and pressure changes behavior. As this order circulated among Trump's legal and political circle, one reality became impossible to ignore. The firewall they built around these documents is cracking. What happens next could determine not just the strength of the prosecution's case, but the willingness of Trump's advisors to continue standing shoulder to shoulder. Because when legal risk becomes personal, loyalty weakens fast. And this is only the beginning. To understand why this moment is so dangerous for Donald Trump and the people around him, you have to understand the person on the other side of the bench, and why she was never going to tolerate the strategy Trump's team assumed would work. The federal judge overseeing this case is not new to politically sensitive prosecutions. Long before this case landed in her courtroom, she built a reputation for something Trump's legal team dreads: procedural discipline. She is known among attorneys as methodical, detail-oriented, and deeply skeptical of vague legal arguments that rely more on assertion than evidence. From the start, she made it clear that this case would move forward on the court's schedule, not the defendant's. That mattered, because Trump's lawyers arrived with a familiar playbook. They filed early motions warning of unprecedented complexity. They emphasized the volume of materials involved. They raised concerns about executive privilege, classified information, and overlapping investigations. Each argument, on its own, sounded reasonable. Together, they formed a pattern the court immediately recognized: delay by accumulation. Instead of refusing outright, the judge initially allowed limited flexibility. Deadlines were adjusted. Briefing schedules were expanded. She gave Trump's team room to demonstrate good faith. But good faith has a shelf life. As weeks turned into months, prosecutors began pointing out inconsistencies. Documents described as privileged were being referenced by witnesses who were not attorneys. Communications allegedly protected by confidentiality had been shared across wide distribution lists. Some materials withheld from prosecutors appeared to have little to do with legal advice at all. The judge noticed. In court filings and status conferences, her language began to change. Questions became sharper. Explanations were no longer accepted at face value. When Trump's attorneys leaned on generalized privilege claims, the court asked for specifics and didn't receive them. This is a critical moment in any federal case. When a judge stops assuming compliance and starts testing credibility, the balance of power shifts dramatically. The turning point came when prosecutors formally challenged the scope of Trump's privilege assertions. They argued that the defense was using privilege not as a protective doctrine, but as a blunt instrument to obstruct discovery. They emphasized that discovery is not optional. It is a constitutional requirement designed to ensure fairness and transparency. Prosecutors didn't ask the court to immediately turn over the documents. Instead, they asked for something more strategic: visibility. They requested a detailed privilege log. This is where the judge's experience mattered. A privilege log is not a symbolic gesture. It's a legal pressure device. It forces the party claiming privilege to commit to concrete explanations under penalty of sanction. Every entry locks the defense into a position that can later be challenged, contradicted, or exposed as inaccurate. The judge granted the request. But she didn't do it gently. Her order was explicit, direct, and unusually firm. Trump's team was instructed to produce a comprehensive log within 5 days, a timeline that sent an unmistakable signal that the court believed delay had already gone too far. No vague categories, no umbrella claims, no open-ended extensions. Each document would be accounted for individually. In federal court, this kind of order is a warning shot. Judges do not escalate to this level unless they believe something is being withheld improperly. And Trump's attorneys understood exactly what it meant. In normal circumstances, privilege logs are time-consuming but manageable. In this case, the scale is enormous. The materials at issue span months of communications, involving multiple advisors, lawyers, political operatives, and outside figures. Each entry requires careful analysis, because a single mischaracterization can collapse an entire privilege claim. And worse, a flawed entry doesn't just risk losing protection for one document. It can undermine the court's confidence in the defense altogether. That's why this order is so destabilizing. Trump's legal strategy has depended on ambiguity, on not having to fully explain who was involved in what and why, on keeping prosecutors guessing about the existence and nature of certain communications. The privilege log destroys that ambiguity. It forces Trump's team to map the terrain for their adversary, and the judge knows this. Her courtroom history shows a consistent pattern. She does not reward gamesmanship. She does not tolerate vague compliance. And once she believes a party is pushing boundaries intentionally, she moves quickly to enforce rules. That enforcement power is substantial. If the court determines that privilege claims are being abused, it can order documents disclosed outright. It can impose sanctions. It can limit future claims of privilege. In extreme cases, it can draw adverse inferences, essentially allowing prosecutors to argue that withheld evidence would have been damaging. None of those outcomes favor Trump. The judge's posture also sends a signal beyond this single dispute. It tells prosecutors that the court is open to scrutiny. It tells witnesses that obstruction will not be indulged. And it tells Trump's advisors that the era of endless delay may be over. This is where internal pressure begins to mount. Because once a privilege log is filed, advisors can no longer hide behind collective strategy. Each document implicates specific individuals. Names appear. Roles become clear. Decisions are traceable. And that's when people start thinking defensively. Who else was copied on that email? Why was that memo shared outside legal counsel? Who insisted it be framed a certain way? These are not abstract concerns. They are liability questions. The judge's order didn't just accelerate the case. It changed the psychology of everyone involved. Trump's legal team now has to balance two competing risks: protecting the former president while avoiding personal exposure. Those interests do not always align, and judges understand that dynamic well. By forcing precision, the court has created conditions where fractures become more likely, where cooperation weakens, where silence becomes harder to maintain. This is why Trump's advisors are uneasy, not because of what has already been revealed, but because of what they may now be forced to reveal themselves. The judge didn't accuse them of wrongdoing. She didn't need to. She simply enforced the rules. And for a defense built on delay and opacity, that may be the most dangerous move of all. The moment Judge Chuckin issued that order, the danger shifted away from Donald Trump alone and onto the people who have spent years orbiting him. What had once been a shared legal shield, privilege, loyalty, silence, began to transform into a liability that no one could fully control. Because privilege is not a blanket. It is narrow, fragile, and conditional. And under pressure, it cracks. For years, Trump's inner circle operated on the assumption that proximity to power created protection. Communications flowed freely between lawyers, political advisors, media operatives, and outside activists. Strategy discussions blurred into legal advice. Political planning mixed with legal positioning. In ordinary times, this kind of overlap might go unexamined, but federal court is not ordinary. Judge Chuckin's order forced Trump's legal team to confront a reality they had been avoiding. Most of these communications were never cleanly privileged to begin with. Attorney-client privilege applies only to confidential communications made for the purpose of seeking or providing legal advice. The moment a non-lawyer is looped in, that protection can evaporate. And in Trump's world, non-lawyers were always present. Political consultants, campaign officials, media strategists, loyalists who were neither attorneys nor government officials, but were still deeply involved in planning. Emails, texts, and memos circulated widely, often without regard for how they would look later. Now, each of those documents must be justified line by line. This is where privilege turns into a trap. Because claiming privilege requires asserting facts: who sent the document, who received it, what it discussed, why it qualifies. Each assertion becomes a sworn position that can be tested and challenged. If prosecutors show that a document claimed as privileged was shared with someone outside legal counsel, the privilege fails. If the content reflects political strategy rather than legal advice, the privilege fails. If the discussion involves potential wrongdoing, the crime-fraud exception applies, and the privilege fails entirely. That exception is particularly dangerous here. The crime-fraud exception holds that communications are not protected if they are made in furtherance of criminal or fraudulent activity. In other words, lawyers cannot be used as shields to plan illegal acts or conceal them. Prosecutors have already signaled their intent to invoke it. They argue that some communications involve efforts to pressure state officials, organize alternate electors, or obstruct certification of the election. If the court agrees, entire categories of documents could be ordered disclosed regardless of privilege claims. That prospect terrifies advisors. Because unlike Trump, many of them do not have the same political insulation. They do not have crowds chanting their names or campaigns fundraising off indictments. They are private citizens with reputations, careers, and families. And now their names may appear on privilege logs that prosecutors will dissect publicly. This is when loyalty starts to crack. When advisors realize that protecting Trump may require exposing themselves, self-interest takes over. Legal counsel begins asking different questions. Not how do we protect the team, but how do we limit your individual exposure? That shift is subtle, but devastating. Once advisors consult separate attorneys, unity dissolves, strategies diverge, information stops flowing freely, people become cautious about what they say and to whom. Federal prosecutors recognize this moment well. It is when cases begin to accelerate. The judge's order forces Trump's team to produce the privilege log quickly. 5 days is an extraordinarily short window for a document of this scale. That means decisions are being made under pressure with limited time for coordination. Mistakes are likely, and in federal court, mistakes have consequences. If the privilege log is incomplete, the judge can reject it outright. If entries are vague, she can demand revisions or order disclosure. If she believes the defense is acting in bad faith, she can impose sanctions. Worse still, inconsistent positions across filings can be used to challenge credibility later. This is why advisors are anxious. They know prosecutors will compare the privilege log to other evidence: witness testimony, seized devices, communications obtained from third parties. Any discrepancy becomes a crack prosecutors can widen. For example, if an advisor testifies that a meeting involved political messaging, but the privilege log claims it involved legal advice, that contradiction matters. If emails produced by another witness include people omitted from the log, that matters too. Every inconsistency is leverage, and prosecutors are patient. The internal tension this creates is immense. Some advisors believe the safest move is full compliance. Disclose what must be disclosed, preserve credibility with the court, and limit future exposure. Others argue for aggressive resistance, challenge every demand, appeal every ruling, and frame compliance as surrender. Those positions cannot coexist peacefully. Trump himself favors confrontation. His public messaging depends on portraying every legal action as persecution. Cooperation undermines that narrative. But advisors are not running for office. They are trying to avoid indictment. That difference in incentives is critical. The judge's order doesn't just require documents, it forces a reckoning. Who is this defense really for? Is it about protecting Trump at all costs, or about minimizing individual risk? As those questions surface, fractures widen. Some advisors may argue they relied on lawyers' guidance. Others may argue they were acting under political direction. Responsibility begins to shift, quietly at first, then more openly. Federal cases often turn not on a single piece of evidence, but on the unraveling of collective silence. Once one person breaks ranks, pressure increases on others. And privilege logs help that process by naming names. They turn abstract strategy into a documented chain of responsibility. That is why Judge Chuckin's order is so powerful. It doesn't accuse, it exposes structure. And once structure is visible, accountability follows. Trump's legal team now faces a ticking clock. Every hour brings them closer to filing a document that could reshape the entire case. They must decide what to claim, what to concede, and what risks to accept. And every advisor knows, once it's filed, there's no taking it back. The silence that protected them for months is ending. By the time Trump's legal team fully grasped the implications of Judge Chuckin's order, it was already too late to undo the damage. The ruling wasn't just firm. It was strategically suffocating. Every available option carried serious risk, and none offered a clean escape. This is what makes the order so devastating. It eliminates the middle ground. For months, Trump's lawyers operated in the gray space between compliance and defiance. They produced some documents while withholding others. They responded to court directives, but slowly. They claimed cooperation while simultaneously obstructing access to key materials. That balancing act allowed them to project reasonableness without surrendering control. Judge Chuckin shut that down completely. Her order forced a binary choice: comply fully and expose sensitive material, or refuse and face immediate consequences. There is no third path. And those consequences are not symbolic. Federal judges possess broad enforcement authority, particularly when it comes to discovery violations. If the court determines that a party has willfully failed to comply, it can impose sanctions ranging from fines to evidentiary penalties to contempt findings. In extreme cases, contempt can include jail time, even for attorneys. That threat is now real. The 5-day deadline was not arbitrary. It was designed to prevent further maneuvering. By compressing the timeline, the judge ensured that Trump's team could not file endless motions seeking clarification or delay. Any attempt to do so risks being viewed as defiance rather than advocacy, and federal courts do not tolerate defiance lightly. If Trump's lawyers miss the deadline, submit an incomplete privilege log, or rely on boilerplate explanations, the judge can rule that privilege has been waived entirely. That would mean the disputed documents would have to be turned over immediately, without further argument. In legal terms, that would be catastrophic, because waiver doesn't just apply to one document. Courts can find that a pattern of noncompliance justifies broader disclosure. Once credibility is lost, judges stop giving the benefit of the doubt. That is the position Trump's team now finds itself in. They must produce a document that exposes the existence and nature of communications they've fought to conceal, while simultaneously trying to preserve privilege where possible. Every entry must be precise. Every claim must be defensible. Every omission could be fatal, and prosecutors will scrutinize it aggressively. This is not a passive review process. Prosecutors will challenge entries they believe are overbroad. They will compare the log to evidence already obtained. They will argue that certain claims are inconsistent with witness testimony or documentary proof. The judge will then decide, document by document, what stays hidden and what comes out. This is where the no-win nature of the situation becomes clear. If Trump's team is conservative and discloses more than necessary, they risk handing prosecutors powerful evidence voluntarily. If they are aggressive and assert privilege broadly, they risk angering the court and triggering sanctions. Either way, control is lost. And loss of control is the one thing Trump's legal strategy has always tried to avoid. This dynamic is particularly dangerous for advisors whose exposure depends on how documents are characterized. A memo described as legal advice might be protected. The same memo described as strategy might not. Small wording choices carry enormous consequences. That's why internal disagreements are intensifying. Some lawyers argue that preserving credibility with the judge is paramount, that limited disclosure now is better than forced disclosure later. Others argue that any concession invites further intrusion and undermines the defense narrative. Those disagreements are not academic. They affect real people. Advisors who believe certain documents are incriminating may push for aggressive privilege claims. Others, fearing contempt or professional discipline, may resist that approach. Attorneys themselves face risk here. If a court finds that lawyers knowingly misrepresented privilege claims, professional sanctions could follow. Judges can refer misconduct to bar authorities. Careers are on the line. This creates a divergence of incentives between Trump and his legal team. Trump's political survival benefits from confrontation. His lawyer's professional survival benefits from compliance. Judge Chuckin understands this tension and has weaponized it. By forcing decisions quickly and publicly, she has placed Trump's defense under immense internal strain. There is no time to smooth over disagreements, no time to negotiate consensus. The deadline forces action, and looming over all of this is the specter of contempt. Contempt of court is not theoretical. Judges have used it repeatedly in high-profile cases when parties refuse to comply. Penalties can include daily fines, exclusion of evidence, adverse jury instructions, or incarceration until compliance is achieved. The court does not need to wait for trial to impose these consequences. This is why Trump's advisors are alarmed. They are not accustomed to being personally subject to court enforcement. Many assumed that proximity to Trump insulated them, politically and legally. This order shatters that illusion. No advisor wants to be the test case. No lawyer wants to be the one sanctioned. And no one wants to explain to a judge why a deadline was ignored. This is the trap Judge Chuckin has set. It is procedural, not political. It relies on rules that apply to every defendant, and it forces accountability without rhetoric. Trump's team can rage publicly, but in court, only compliance matters. As the deadline approaches, every decision becomes fraught. Every conversation is cautious. Every email is reconsidered. Because once the privilege log is filed, the next phase begins. And that phase is about what the documents reveal, not what the defense says about them. As the 5-day deadline looms, the public sees only silence from Trump's camp. But behind the scenes, the atmosphere is anything but calm. What Judge Chuckin's order has triggered is not just legal stress, but a cascading crisis of confidence among the people closest to Trump. Because once documents begin to surface, or even once their existence is formally acknowledged, narratives start to collapse. For Trump's advisors, the danger is not limited to what prosecutors might uncover. It's also about how the public, political allies, and potential jurors may interpret what comes out. Context is everything, and documents rarely speak kindly to those who expected secrecy. Internal communications that once felt routine can suddenly look damning when stripped of nuance and read in court. Casual language becomes intent. Speculation becomes planning. Silence becomes implication. That reality is now setting in. According to people familiar with similar federal cases, moments like this often mark a turning point, when advisors stop thinking collectively and start thinking defensively. The shift is subtle but unmistakable. Phone calls get shorter. Messages become guarded. Conversations move offline. And most telling of all, separate lawyers enter the picture. When advisors begin seeking independent legal counsel, it's a sign that unity has fractured. It means individuals no longer trust that a single legal strategy serves everyone's interests. They want advice tailored to their own exposure, their own communications, their own risk profile. That alone weakens Trump's defense. Because a unified front relies on shared assumptions, shared risk, shared loyalty, shared silence. Once those assumptions break down, coordination suffers. Information stops flowing freely. People begin hedging, and prosecutors know exactly how to exploit that. They understand that legal pressure doesn't just extract documents, it changes behavior. People who once believed they were protected begin to reconsider what they're willing to shield, especially when the alternative involves contempt sanctions or professional ruin. This is where Judge Chuckin's order has its greatest effect. It doesn't need to force immediate disclosure of incriminating evidence to be effective. It merely needs to apply pressure in the right places. The stress fractures do the rest. Politically, the consequences are equally significant.